Hello, hello. Hi, guys. Hope everyone's doing well today. Hope everyone is well. I think I got my notification that I'm live. Yes. Guys, thanks for being here. Just waiting for some folks to pile on in. Hope you can hear me okay. Today's video is brought to you by Noble Gold. Stuck by me through this whole entire time. Love them as a sponsor. They're fantastic. During the lockdown, I've started doing a ton of things differently. My kids are home all day. Craziness with homeschooling, which is actually ending up to be a blessing in disguise. But talking to a lot of friends virtually, they feel the same way about this stuff. Recommending apps and TV programs, other ways of kind of laughing. I've been watching TikTok. I know it's Chinese. I know. Don't go out to me. If you've seen the returns on the stock market since the beginning of the year, since the virus, it's clear the old ways aren't working too well. The Fed is propping up returns. It's pumped trillions of dollars into the system to try and avoid what looks like an inevitable collapse. And you can't have 20% unemployment. That's over 26 million jobs. 26 million without some kind of fallout. You can't spend trillions bailing out businesses with no consequences either. So we have to secure a way to guard our wealth, our savings, and our investments. Gold, silver, palladium, platinum, proven to be safe haven investments. It's the only investment with appreciating value during times like these. If you're interested in securing your wealth, make sure to call Noble Gold Investment at 877-646-5347. That's 877-646-5347, or visit noblegoldinvestments.com. Make sure that you guys tell them that Tracy Bean sent you over. They have supported me throughout this entire debacle. So, there's that. On with the show, as someone says, bringing in my lovely Facebook, D-Live, and Periscope audience. Hello, everyone. Okay, so there's been a lot of stuff happening. I haven't come on and done a new video since the last one I did, kind of explaining the whole shebang. And since then, we've gotten two sort of bombshell filings by the Department of Justice in this case. The Department of Justice, Jensen, is a U.S. attorney assigned by William Barr to take a look at the special counsel investigations cases, one of which being General Flynn's, and also in tandem with Timothy Shea. Timothy Shea, who is the U.S. attorney in the Washington, D.C., who replaced Jesse Liu. Jesse Liu who? And we got... You know, unless you guys have been sort of living under a rock, you probably know, so I'm not going to spend a gazillion years going through it all, but we have basically prima facie evidence that the government, the FBI at the highest levels, and probably the Obama administration, I'd reckon to guess, had set up General Michael Flynn for a perjury trap, trying to either get him prosecuted or get him fired. And this was literally in plain English. Hi, guys. Hi, everyone who's saying hello. Literally in plain English, written down with pen on a piece of paper. Even Frank on the Quite Frankly podcast, where we had Svetlana Lakova on Friday as a guest, said, you know, this is in ink. There's probably DNA on it. It's not like they can say that this didn't happen. And he's correct. There was that. There was the attorneys in the case, Covington and Burling, saying, oops, we found, 100,000 more documents that we needed to give you guys in our cursory review of everything. Whoops, here it is. And then we had the judge coming out and saying, hey, you guys better produce every single thing that you have. Look through your records again. Make sure you didn't miss anything and provide everything. So there's a bunch of different things going on all at once in this case. And it's very overwhelming because there are several different tangents that this thing is going on. Friday, the judge issued a minute order that said, okay, government, okay, Sidney Powell and Mike Flynn, General Flynn, don't submit anything else. No more supplemental motions, no more, docket filings until the DOJ has produced every bit of exculpatory evidence they have, not just giving it in piecemeal, right? Show us everything you have, then Sidney Powell, go ahead and file what you need to file. So we're not going to be getting these little productions of 12 documents, 5 documents, 4 documents as time goes on. We're going to get it all at once, and that's what the judge has ordered. If you want to see what has been going on in this case, you can go to uncoverdc.com, and I have 2 articles that I posted about this that explain it in detail. So you can go ahead and go and read through all that. Today, interestingly enough, the law firm Covington and Burling came back and said, okay, we found more. And here is their 10-page notice of compliance to the judge, saying, okay, judge, you filed a minute order saying we need to go look through all of this stuff again and refile if we need to. We did that. Here's our notice of compliance. This will be the second notice of compliance there's been. Okay. This one, I don't know what everybody else's analysis of it is going to be, but mine in particular, my analysis of it, and I'm not a lawyer, so there's a ton of really great people out there that do analysis on this stuff that might not agree with me, but just going to say, they go through in this filing a list of actions that they took prior to the April 28th order, which was the last one, where the judge, in very strong words, let's find it here. Motion for leave to file second supplemental notice regarding transfer of case file to successor counsel, meaning transfer of the files from Covington and Burling to Sidney Powell. The judge says it is hereby ordered that Covington and Burling's second supplemental notice regarding transfer of case file to successor counsel is deemed filed. It is ordered that Covington and Burling shall re-execute a search of every document and communication pertaining to the firm's representation of Mr. Flynn. It is further ordered that Covington and Burling is forthwith directed to produce Mr. Flynn's successor counsel all documents or communications concerning the firm's representation of Mr. Flynn that were not previously transferred in the rolling productions. It is further ordered that Covington and Burling shall file a notice of compliance with this order no later than 12 p.m. on May 4th, 2020, which they did. So, given all that, reading through this today, this is what I think. They said what actions they've taken previously. They say they had produced to successor counsel approximately 669,800 documents, which included pleadings, documents submitted to the government, documents submitted to the court, client interview notes, third-party interview notes, more than 1,000 pages of handwritten notes, legal research memoranda, factual research memoranda, strategy memoranda. And let me just explain to you the propaganda that's going on here. They're listing this big exhaustive list of all the things they've provided because they're trying to make it seem as though they have gone above and beyond in providing all this information. And, the little things they missed are no big deal. Look at all the stuff we gave. Well, if all the stuff that you gave omits the 3 things that are most important, then the rest of the crap you gave as a paperwork task doesn't matter. It's uncoverdc.com, 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 uncoverdc.com. Somebody was asking for the website. So all of this stuff, document binders, proffer session binders, interview binders, time records, correspondence, text message, voicemail messages, emails, including emails written as part of the representation that were internal to Covington, between Covington and Mr. Flynn, between Covington and third parties, and between Mr. Flynn and third parties. Just remember all of this for a second. Documents collected from Mr. Flynn and from third parties, and documents produced to third parties, Congress, Department of Justice, Special Counsel's Office, and to counsel for Bijan Rafikian. Covington retrieved these document categories from a number of physical locations and electronic media, which they discuss here in detail. Documents saved outside the working case file on Covington hard drives by key lawyers that handled the case. Documents on the firm's document management system, including those that were stored under the client matter numbers for Mr. Flynn and Flynn Intel Group. Because remember, Covington and Burling were retained by General Flynn to work on looking at whether or not General Flynn needed to file FARA. That's what they were brought on for. So they come on for the FARA case, they represent him in the FARA case, and then he gets involved with the special counsel and they represent him in that as well. Okay. Excuse me. Handwritten notes concerning representation taken by lawyers in connection with, they go through this exhaustive list. They talk about all the things technically outside of what they're supposed to give that they gave, and all kinds of stuff like that. Identification of Flynn-related emails by key lawyers on the matter. This is the methods they used to search for those things, right? So they get down and they say, after identifying emails from the relevant databases as described above, Covington reviewed them to determine whether each one was or was not part of the client file, as distinguished from emails about a variety of matters that applicable authorities state are not part of the client file. Here we go. Here comes the spin. Here comes the spin. Examples of the latter include communications with and within firm management about case staffing, workloads, and other management issues. Okay, understandable. Communications among firm personnel about how to respond to invitations to panel discussions or requests for media comments about a wide variety of topics, given the firm's representation of Mr. Flynn, and firm's lawyers' opinions regarding the effect of the firm's representation of Mr. Flynn on their latitude to engage in such commentary. That should be included, given what we know. They're arguing it shouldn't. Communications about billing and collections, and Covington lawyers' privileged consultations with the firm's internal counsel regarding ethical and compliance obligations. Seriously? An additional category of documents that are not part of a client file under applicable authorities and thus were not included in the client file transfer are communications referring to the Flynn engagement in the context of conflict checks relating to prospective clients. Whether or not those clients became clients, Covington is obligated to preserve their confidences and all privileges, which I get. That's fine. Great. Thus, what Covington transferred to successor counsel before the order was the client file as distinct from each and every communication concerning the firm's representation of Mr. Flynn. They did this in accordance with the understanding of the court's minute order of July 16th, which relates successor's counsel's concern that he had not yet received the client files from Covington. Then there's the minute order that Covington's approach was consistent with all the relevant rules. They go through ad nauseum, detailing all the rules they complied with, and their ethics, their compliance with ethics guidelines is discussed here, and they're giving themselves little outs here on why they shouldn't have to produce things, why ethically they shouldn't have to produce certain documents. Listen, to me, so far through this, 5 pages, all I've seen is a bunch of about to cover their butt for not providing things that they should provide, or not providing things that are material to what Sidney Powell's arguing. Then they say how they complied with the order of re-going through everything. They verified it accurately executed their collection and review protocol. They compared the handwritten notes, blah, blah, blah. They say 16 pages of that stuff actually should have been given over, which they didn't give over, and now they're giving over today. They spot-checked electronic documents previously coded by reviewers as not being part of the client file to confirm that they were properly coded. They validated their process. Flynn's successor counsel, here we go. This is where it gets interesting. Notwithstanding all the foregoing, Mr. Flynn's successor counsel has taken the position in correspondence with Covington that the April 28th order requires Covington to search for and produce a wide range of documents significantly beyond the client file. Things they were talking to themselves about that they didn't put in the client file, probably because they wouldn't have wanted them in the client file so that they didn't get out. Sidney Powell is arguing that the judge's order that he just made includes those things. Covington is saying that it doesn't. So, for example, successor counsel has requested every communication of any kind, including telephone records of every call. Why? Because they want to see if they were on the phone with the DOJ and when. Or anyone else, for that matter, that may have been a swamp rat nonsense person. Including telephone records of every call of every Covington employee in which the Flynn case is mentioned. Well, yeah. Why is your law firm running around talking about the Flynn case if they're not on the case? And if so, what were they doing outside of the case file? To accept successor counsel's interpretation would require Covington to conduct a massive sweep of its servers for every document and communication pertaining to the firm's representation of Mr. Flynn, extending to every instance where any firm lawyer made any comment about the firm's high-profile representation of Mr. Flynn. That would be a disproportionately burdensome e-discovery process of great scale and duration. Now, this is my opinion of why they just basically put the nail in their own coffin. The judge probably isn't going to agree with me, but this is my opinion. In fact, Covington already has engaged a respected e-discovery vendor to address a broader collection and review process to encompass the documents concerning the Flynn representation. Why would they do that if they thought that they didn't have to? Why would they engage in that if they thought that they didn't have to? Why would they even go there? That vendor said that just the initial collection and processing would take many weeks to complete. They're threatening to draw the case out. They have stuff that they don't want out there. I argued from the beginning that if they argued a privilege issue, they were trying to cover their butts. But I think that this here is that squared. Because their lawyers, they could have had a lawyer outside the case file going and doing stuff and not including it in the case file just to be shady, which I don't put it past them given all the other things we've witnessed from this law firm. Anyway, they're basically saying this would be ridiculous and exhaustive. Even such an expanded search extending far beyond the client file wouldn't ensure that all documents pertaining to the representation were captured. Like, we can never guarantee that we get everything. We're just a law firm that does this for gazillions of clients. Understand, this is the law firm that was representing Flynn previously trying to cover their butts. This is not the DOJ. That is why the long and well-established standard practice for collecting and reviewing massive amounts of electronically stored information requires the use of search terms. In fact, even in civil cases addressing document requests and subpoenas far broader than a client file, courts recognize that review and production of ESI doesn't require and cannot achieve perfection. In other words, please just allow us to screw up. There's no way we could ever be perfect. So please don't require that of us. This is just laughable to me. And they give case law to back them up. It's not possible for any attorney to certify that every document pertaining to a law firm's representation of the client has been produced. By this notice, we certify we execute a planned search and review protocol as described above and transfer the results to successor counsel. In the same way, if the focus were shifted to a much broader production than the client file, as successor counsel now demands, even after a lengthy search and review process lasting many weeks, the certification would be the same, i.e. that a particular protocol was developed and executed, but that not every document concerning the Flynn representation was produced. Covington respectfully invites any further guidance based on the foregoing that the court may be inclined to provide in order to help us ensure that we do exactly what the court requires. Covington confirms it diligently executed its protocol to search for and produce the client file as described herein, and accordingly, Covington provides this notice of compliance. So, that being said, that's what happened today. Now, let me just refresh this real quick. I'm getting a phone call. Yeah, so that's the last thing. Hold on one second, guys. Sorry. So I just wanted to talk to you guys a little bit about one more aspect of this case that I think is confusing to a lot of people, which is the FARA portion of this. And you'll see a lot of lefty blue check marks and people in the media who are now saying, well, he avoided this massive criminal liability in the Farah case by pleading guilty, because the question is, why did he plead? Well, then why did he plead if he wasn't guilty? Why did he plead? I mean, it's... I'm going to do a very, very quick high-level overview of the FARA issue for everyone so that you can answer that question intelligently. Okay? General Flynn formed a company called Flynn Intel Group with his son and a business partner, Bijan Rafikian. During the election season, when he started campaigning with Trump, his business partner was running the company. There was an attempted coup in Turkey. And the attempted coup was allegedly by an Islamic cult, as they call it, who he was here living in the United States, the guy who runs it, and he had a bunch of schools and stuff set up in the United States, and there were people in Turkey that were very familiar with U.S.-Turkey relations that wanted an investigation done into this so that greater awareness could be brought to the American people about what was going on. So a private businessman decided he was going to step up and fund this investigation into what happened and publication of this information so that the American public would be informed about what happened. The private businessman was friends with the business partner at Flynn Intel Group and contracted them to do a certain set of tasks to accomplish this. The private business was not being paid by the Turkish government. Flynn Intel Group was not being paid by the Turkish government. I think it was before the election, it might have been right after the election, General Flynn gets a letter from the government that says, you guys may want to consider looking at what looking at your records and filing a FARA form, just to make sure, just make sure you guys are in compliance, because if you do work for a foreign government, you need to declare that you were working for a foreign government. It's not illegal to work for a foreign government, but you need to declare it. FARA. He hired Covington and Burling to come in and do an exhaustive review of everything that Flynn Intel Group had done to determine whether or not they needed to file this FARA registration. You can file FARA retroactively. If he had needed to file FARA, he could have done it retroactively. The lawyers, Covington and Burling, said to him, you really don't have to file FARA, but just to be on the safe side, to dot all the I's and cross all the T's, file the FARA registration. We'll do it to the best of our ability. And they did. Okay. Mike Flynn Jr. worked for Flynn Intel Group with Mike Flynn Sr., General Flynn, and they were hands off of this for the large majority of this specific contract. They were hands off. They interacted with it a bunch of times, but it wasn't their main focus. They were on the campaign trail. Fast forward to the special counsel. The special counsel comes in and says, you were working with a foreign government and your FARA filings aren't good enough, and we're going after your business partner criminally, and we're going to go after your son criminally unless you plead guilty to lying to investigators when you talk to Pienka and Strzok. If you do that and you cooperate us so we can get your business partner on a criminal violation, we'll let your son walk on this, quote, FARA malfeasance that never happened. Never happened. Long story short, again, glossing over a whole bunch of detail, the DOJ takes that case. Michael Flynn, General Flynn, is cooperating in that case, providing all kinds of documents, interviews, dozens and dozens of hours, talking to them, working with them. They go to trial, and there was an error. There was a small problem with the filing that Covington and Burling were responsible for. And the government says to General Flynn, now that he had it, and again, there were conflict of interest concerns throughout, because Covington and Burling was on the hook for the FARA mistake, but they were also representing General Flynn in the criminal aspect. So there were ethical concerns about this. I hope this is making sense to everybody. So there were ethical concerns, and those persisted. Long story short, after the special counsel disbands, Sidney Powell comes in on behalf of General Flynn, and the government says to General Flynn, we need you to get up on the stand and say that you knowingly lied on your FARA filing. General Flynn said, I did not knowingly lie on my FARA filing. Not only did I knowingly lie, nor would I ever stand up, put my hand on the, take an oath to tell the truth, and then say I lied when I didn't. They were trying to get him to do what they alleged he did in the special counsel investigation, and he refused to do it. Once he refused to do that, the government basically lost their entire case against his business partner because there was no crime at all. They had an FBI forensic expert in that case say that they could not find 1 red cent of money coming from Turkey. All of that happened. The judge dismissed, the judge says, okay, jury, it's time for you to, vote on the conviction or whatever. The judge convicts this gentleman, the business partner, of the alleged offenses. The government does a complete 180 on all of the things it had ever said about General Flynn leading up to that moment. And not only that, when General Flynn says to the government, I'm not going to lie for you, especially not when no, I will not do something like that for you, which is what the special counsel pressured every single person to do, by the way. Make up a lie about President Trump. Michael Cohen had no problem doing that to save his own ass, little weasel. Anyway, they went after Mike Flynn Jr. again. Now, mind you, there was nothing they were going to charge him with something that he didn't do and make his life a living hell. They threatened to put him in solitary confinement. And so General Flynn, to avoid his son with a new baby, who is a fine man, just to let you know, who I've spent time with, and the whole family is beautiful. Long story short, they threaten his son again, and this is when things really go off the rocker. Now, there's a conviction in that case against the business partner. So when Ben Wittes says that the business partner, this horrible criminal case of all this criminal malfeasance with Turkey, the traitor, the judge in the case looked at the jury, looked at the verdict, and said, in D.C., a highly politicized case in D.C., looked at it and said, hell to the no. We are overturning this. I am overturning this criminal verdict. There is no way that I'm going to allow this to stand. You did not prove your case at all. Let me see if I can find it. Maybe not now. Maybe not now. Now's not a good time. But long story short, the judge wrote a scathing overturn. Let me see. Hold on. Here. A federal judge has overturned a jury verdict convicting Michael Flynn's former business partner of illegally lobbying for Turkey, finding the evidence against him was insufficient. The verdict was against the heavy weight of the evidence, says Trenga. The decision is another blow to efforts by the Justice Department to crack down on unregistered lobbying for foreign governments. White House counsel Greg Craig was recently found not guilty at trial of lying about his work for Ukraine. Greg Craig, former counsel for Barack Obama. And this week's prosecutors closed an inquiry into 2 other high-profile lawsuits that did work there. Trenga had signaled his skepticism throughout Rafikian's trial, ruling there was not enough evidence to establish a conspiracy between him, Flynn, and a Dutch-Turkish businessman named Camille Akim Alptekin. I can't say that right. Bijan and his family are relieved and looking forward to getting on with their lives. We're all grateful to the court. Flynn, and it goes on and on and on. So anybody who tells you this was some big, criminal investigation that would have just taken them down and there was no way they would have gotten out of it is just lying to you. Plain up. Lying to you. Just know. Understand that, okay? So now we're waiting for the government to produce more. And I believe that Sidney Powell said today,
so they set Flynn up. They set Flynn up. They interviewed Flynn in the White House.
He looks great.
Without telling him he was being interviewed. Without warning him what would happen if he made misstatements. Without telling him he could have had a liar. They staged it. Hey, buddy, welcome to Washington. Welcome to the administration. We're the FBI. Great to be working with you. Just a conversation walking down the hall. It was a total setup. Anyway, there's more, but I have a break. Then I results of 2016.
So that's another interview with Sydney, which hold on, I'm looking for what she posted this morning or earlier. Here we go. Breaking, Covington has found more notes and is certifying its full transfer of the Flynn file for the second time. They provided another 32 pages of handwritten notes and 16 pages of documents with handwritten notations, in addition to the 17,500 new pages produced a week or so ago. Covington Burling says anything more would be too difficult, too expensive, and not required. I was right. Awesome. For key documents in the Flynn case, including the notice of compliance, see SydneyPowell.com, the Michael Flynn case, whatever. So anyway, Covington Burling invites further guidance from the court, hints at unreasonableness of Flynn requests for telephone records that would be specifically those of Eric Holder and Michael Chertoff. This is what they're looking for. So a couple different things just to end off about where we're at. Number one, there are several different ways this could go. I don't feel that the judge is drawing this out or anything of that sort right now at all. This is pretty standard what we're going through right now in terms of when the calendars are set and stuff like that. The DOJ can completely drop the case. The judge can rule that General Flynn can revoke his plea deal, at which time he will go to trial. And then it'll be up to a jury to convict him of lying or not. That I don't see how even the most biased jury on the face of the planet could rule in that way or convict General Flynn of lying to investigators at this point. He could dismiss the case for egregious government misconduct or not. At the end of the day, if the judge decides to rule against the motion to dismiss and rule against the motion to revoke the plea, the DOJ still has the ability to completely withdraw the case and make this all go away. Given their production of Brady material, I think that in my opinion, again, I'm not a lawyer, but in my opinion of reading all of this and stuff, it's my opinion at this point that the judge, that it may be that they're waiting for the judge to rule on egregious government misconduct before they pull the case, because a judgment like that by a judge, and especially a judge who is not a right-leaning judge, he has ruled against Trump and President Trump in the past on things. If he rules that this is egregious government misconduct, and then General Flynn sues the hell out of every last scoundrel that has put him and his family through this for the past 4 years, he has a strong case with that ruling. He has a strong case with the DOJ withdrawing the charges, but he has a strong case with the judge ruling that way. So that's what I think might be going on right now with all of this. So I just wanted to do a quick stream with you guys and bring you up to speed on what happened today in the case of General Flynn. And let you know that I am obviously paying very close attention to this. I want to do another video probably tomorrow where I talk about Stefan Halper. And I probably will explain the bigger picture surrounding General Flynn and why he was such a big target for everybody, to kind of like refresh that as well. Also, I'm rereading the FISA report with new eyes. And I've got my highlighter and my pen, like Catherine Herridge. If you guys appreciate the work I do and you'd like to become a patron, it really, really helps me so much. I know that things are tough for everyone out there right now, but you can find me on Patreon or Subscribestar, patreon.com/TracyBeans with a Z, subscribestar.com/TracyBeans, paypal.me/TracyBeans. All of that stuff keeps me gainfully employed. And I depend on you guys, and I love you very much. Also, check out uncoverdc.com and make sure you go there because we've got a bunch of stuff. I'm going to publish an article by Brian Cates in the next day or so that does a good review and summary of all this. That's it for now. Thanks for standing here with me for about, what was it? I don't know how long I've been talking to you for, half hour or so. Talk to you guys soon. Thanks for your support.